Namaskar, sir.
We'll start the session sharp by 7 o'clock. You can unmute yourself and please read on. Very good evening. Instruction to the participants. Please kindly mute yourself. You will be given a chance of Q&A session that you can put in the chat box. Please don't unmute. If you have any queries, you can raise your hands. Thank you. And can you just call the resource person and see? I was trying, I'm not getting it. Hello, are we good to go? Hello.
Yes, yes, you can.
Ma'am, you're mute. You're on mute.
Am I audible?
Yes.
Yes, yes.
Yes, yes.
Yes, you're audible. We'll start the session, Anusri.
Okay.
Okay. Hi, everyone. I hope everyone's on board and can listen to us. Am I audible?
Yeah, you are audible.
Okay. So, a very good evening to each one of you present on the other sides of the screen. I, Bhagya Padyar of third year LLB, take immense delight in welcoming you all to the first day of the LG Havanur Endowment Special Lecture that is going to be held from today, that is 12th of November 2025, to the 19th of November 2025. So, a warm welcome to the members of the management, our principal, Srimati Lalita M. Ma'am, our teaching staff, our non teaching staff, and first and foremost, our keynote speaker, uh, Anushri Ma'am, who is here from all the way from Tamil Nadu. She's joining us. And to the students who are
It's from Kerala.
she's from Kerala, but I was referring to her LinkedIn. It showed Tamil Nadu, so I'm and she practiced at Madras High Court, so I was confused if she's from Kerala or Tamil Nadu.
Yeah, I'm
Okay,
originally from Kerala, but right now settled and practicing here in the Madras High Court.
okay, yeah. So welcome, ma'am.
Thank you.
I'd like to speak a little about our founder because the name itself of our online lecture series is LG Havanur Endowment Special Online Lecture. So, Havanur College of Law, as we know it today, it was the brainchild of our founder, LG Havanur. He is popularly known as LG Havanur, but his full name is Lakshman Gullappa Havanur, who was the former law minister of Karnataka from 1978 to 1980. So he initially first was the chairman of the Backward Classes Commission during the then Honorable Devraj Aris's government. He was the chairman of the Backward Classes Commission. Then what happened was he gave a very beautiful report. So, looking at the report, our then Honorable Chief Minister, he inducted him into his cabinet and he made LG Havnur sir the law minister. So, from 1978 to 1980, he served as the law minister of Karnataka. And after that, after the Backward Classes Commission was established, there also came into picture Mandal Commission. which is called as the All India Backward Classes Commission, which we popularly know it as the Mandal Commission. So he was also selected and appointed by the central government as an expert member in the Mandal Commission. So we are really proud to be a part of this institution, which was founded by the then law minister. After which, in 1979, while he was the law minister of Karnataka, in 1979, he found a foundation, that's Socio Legal Services and Resource Foundation. His main intention was to enrich not just legal education, but there are plenty who don't have the means or access to law or to legal aid. So to promote that access, that is to be a bridge between the poor people and the ones who are backward and who do not have access to easy law, that is legal aid. He found the SLS RF as we know it today, and Havanur College of Law falls under the umbrella of SLS RF. So after the demise of LG Havanur sir in 2006, it is his children who are continuing the management of the foundation. And at this juncture, I also would like to pay my tribute to Mr. Ashok uh, Havanur, who is the son of LG Havanur, who passed away last year. So my condolences to their family as well. They have been excellently running this institution and giving access to legal aid and legal education to all and sundry. So coming to this lecture, why did we organize this lecture? Is because apart from what happens in under the four walls of our classroom, we have to know what actually happens in the legal world. For people who do not participate in internships, it is hard to gain knowledge about the practicalities of in the field of law. That is why we have with us our keynote speaker today, who I think is inaugurating the lecture today by being the first speaker during the first day. That is Advocate Anushri Suresh. So, Advocate Anushri Suresh, ma'am, I take immense pleasure in welcome you again. She is a BA LLB and she has a diploma in cyber law. She also has a postgraduate diploma in child rights law. So, I don't know how if we can all clap or put an emoji, because normally during stage functions we tend to clap, right? So yeah.
Thank you.
Yeah, so welcome you, ma'am. She currently serves as the managing partner of Mahadev and Madhav law firm. She is a registered trademark attorney. She has expertise in the field of corporate compliance, service law, civil and corporate litigation at the Madras High Court. Previously, she also served as the Munsif magistrate. So our topic for today is stages of civil suit and order 9 appearances of parties and consequences of non-appearance. So I think there's no one better to explain us about the consequences of non-appearance than a formal civil judge herself. So yeah, ma'am, over to you. Over the floor is yours for igniting our minds. Thank you.
Thank you so much, Bhagya. Thank you so much for that lovely introduction, and
Yeah.
also for the giving us a brief about the history of your college and all that, the founder and everything. That's very good to know how the college came into force and all of that. Anyway, without wasting much time, I think we have a shortage of time. I think, and we have a little broad subject today for discussion. So we'll go to our presentation and we'll start the class now. Okay. Am I audible?
Yes.
Okay, so I'll share. If you have any questions, we'll do at the end of the session. And in case you want me to go back slide, please say that I can do that. In case you want to write it down or anything. So I'll just share my presentation. I hope you all have your civil procedure codes with you. It is always better to read a legislation with the bare acts rather than going in for the descriptive books. First, what we should do is we should read the legislation as it is, that is through the bare act. That is why I mentioned that if you bring your bare acts, it will be easier for you to understand also. So let's start now. Is the PowerPoint presentation visible right now?
Yes,
Can I
yes,
just...
it is.
Yes,
Okay.
yes, it is visible.
So our topic for discussion for today is the stages of civil suit.
Madam, your voice not audible.
I'm not audible.
Yes.
Now
you
you
are
are audible. Now you are audible.
Oh, okay. Okay, I'll begin again then. So today's discussion topic for discussion is stages of a civil suit and appearance of parties and consequence of non-appearance. The first question will be, what is a civil suit? I hope you all have your CPCs with you, right?
Yes, ma'am.
Okay. What is a civil suit? A civil suit is one that will determine and enforce civil rights and obligations. And the rights are entitlements that the people have, and obligations are the duties that they must perform. Now, coming to examples of civil suits, there are property rights suits. There will be property disputes that comes under civil suit. I think somebody's audio is not muted. There is a disturbance in the class.
So
Kind request to all the participants, please mute yourself, and if possible, video is not needed. We can close your camera. Please mute yourself.
So these are examples of civil suits: contractual obligations, family law disputes, consumer rights disputes, tortious liabilities and claims, etc. are some examples of civil suits. Now, what are remedies that are available in a civil suit? As we all know, in civil suit, there is no penalization, right? So, what are the remedies that we have in a civil suit? The civil in civil suits, the remedies that we have are either in the form of injunctions or in the form of declarations, compensations, damages, specific performance, etc. And where do we find these remedies? These remedies are mostly contained in various statutes. First and foremost example will be the Specific Relief Act. It deals with injunctions, declarations, damages, specific performances, everything. Then comes contracts, then taxation laws, transfer of properties. All these statutes will have the remedy in case their rights are violated. Am I being clear? Or is my pace too fast, or should I slow down?
Okay.
Okay, moving on to the next section. So civil law, not just civil law, in law in general can be divided into two major classifications. That is, one is substantive law and one is procedural law. So what is a substantive law and what is a procedural law? That is a core of what we should understand when we are practicing law. Because substantive law is concerned with the actual rights and obligations. That is the law from where these rights and obligations arise. And procedural law, on the other hand, is the process through which the courts will adjudicate your civil, criminal, and administrative cases. So the procedural law determines the process, and substantive law gives right to the actual rights and obligations. So this encompasses the civil rights. It will enlist all the criminal offenses. For example, we have the BNS, which was previously known as the IPC. It is a substantive criminal law. And when coming to civil rights, we have Contract Act, we have Transfer of Properties Act. These are substantive civil laws. And coming to procedural law, we have the Civil Procedure Codes, Limitation Acts, and court fees and suit valuation acts, etc. And the civil side. And in criminal side, we have BNSSS, which is previously known as the Code of Criminal Procedure. So these are the procedural laws. Now, civil law also can be divided into substantive civil law and procedural. Can the moderator mute the other participants? Then it would have been better. Yeah, okay. So civil law also, there is substantive civil law and procedural civil law. And substantive civil law means the Contract Acts, IPR, consumer protection laws, banking and taxation laws, labor laws, family laws. All these laws will contain substantive provisions which give rise to your rights and obligations. And coming to CPC, Limitation Act, court fees and supervaluation, all these things will have the procedure to be followed by the court while they are dealing with these cases, civil cases. Or
There's a lot of disturbance.
am I audible?
Audible. In between the people when they join, no, they don't
Oh, okay.
mute themselves. That's the issue.
I'm audible, right? Yeah.
Yes.
No problem. I'll continue. So here today we are discussing mainly regarding the civil procedure and the code of civil procedure. It is a procedural law that needs to be followed by civil courts in adjudication of civil rights of parties in a civil suit in India. Yes? Okay. So before going into the details of our subject at hand, we'll see what is the scheme of the civil procedure code. So if you have your Bare Acts with you, please take the Bare Act and move on to the contents of the page number. I think maybe in the first 2-3 pages itself it will come contents. So once we understand the scheme of CPC, it will be easier for you to understand the entire, because most of the people, they find civil procedure code to be very difficult, but it can be made easy once you understand the scheme of the civil procedure code. So civil procedure code comprises of sections and orders with rules and appendix. So first, when we look at the contents, the sections, we have 158 sections and they are divided into 11 parts. So 158 sections divided into 11 parts. Then comes the first schedule, which deals with orders with detailed rules in each order. And that order we have from order number 1 to 51. So 51 orders altogether we have in first schedule. Each order will have rules, which is detailed rules in each order. So sections are shown as in numerals and orders are shown in Roman numerals. So we will have to understand how to read Roman numerals from 1 to 51, because that is how we write orders. Now coming to appendices, there is an appendix to the first schedule. The appendix to first schedule has appendices A to H. Appendix deals with forms and what is the formats of filing plaint, and then there are several forms for summons, issuing of summons to witnesses, etc. All these will come under appendices. If you look at for appendices A to H, you can find forms for all the provisions. So and then earlier we had schedules 2 to 5 also, but then right now it's repealed and omitted from the code, so you need not go into that. So what we need to know is that the civil procedure code has 158 sections which are divided into 11 parts. Then the first schedule, which has 51 orders, which is represented using Roman numerals. Each order will have detailed rules. And finally, there is an appendix to the first schedule, that is for the orders, which contains appendices A to H containing various forms and model applications. So this is the scheme of the civil procedure code. Along with the civil procedure code, we have the civil rules of practice, which are the rules which is formulated by the respective high courts of the states by virtue of powers conferred by section 122 of the civil procedure code. So you will have, I think in Karnataka, you will have a civil rules of practice. Kerala, we have a civil rules of practice. Tamil Nadu also has a civil rules of practice. So each high court of the state will formulate these rules for the procedure, whatever that needs to be done with regard to civil rules of practice, they'll have what is the form of the summons, some forms of how the summons has to be sent, what is the process fee, cost of some sending summons. All these things will be detailed in the rules of practice. So this is the entire scheme of civil procedure code. Once you understand this, everything else will be very easy. Now coming to stages of a civil suit. Civil suit, what do you mean by stages of a civil suit? So stages of a civil suit outlines the step-by-step process through which justice is delivered in civil cases, and it begins with filing of the plaint and ends with execution of the decree. Let us just look at the broad classification of stages of a civil suit. We can actually say that there is an institution stage, then there is a pre-trial stage, then a trial stage, final hearing stage, and judgment and decree stage. The first stage is the institution of a suit. It begins with the presentation of plaint in the proper format, and the provisions related to institution of suits is contained in section 26, order 4, and orders 6 and 7, which deals with plaint and how pleadings are to be generally. So all these orders you can write down and you can read through to understand how a suit is to be instituted. Once the suit is instituted, the next stage will be issue and service of summons. And with regard to summons, how the summons is to be issued and to whom it should be issued, and all of these things are mentioned in sections 27 to 32 and order 5. After summons has been served, the next stage is appearance of parties. That is the subject matter of discussion for us today, but we'll get into that later on. But first of all, we'll finish the stages of suits. So once parties have appeared, both parties have appeared, what is the next stage? Once the parties have appeared, then the defendant or the opposite side, opposite party, they will have to file a written statement. So then written statement will be filed by the defendant. After which there will be, if there is any further pleadings, which may include replication. If you ask me what is replication, replication is once a written statement is filed, the written statement may have new claims or certain new facts which the plaintiff need to answer to. So that such facts can be answered through replication. Also, there will be set-offs and counterclaims in written statements sometimes. So in such cases also the plaintiff should be given an opportunity to file the reply or a written statement to those set-offs and counterclaims. So all these things comes within further pleadings. That is mentioned in order 7 and 8. So once all the pleadings are completed, the next stage will be settlement of issues. So what does settlement of issues means? In a suit, once pleadings are completed, we need to identify what are the main issues, because we give a judgment or a decree on the issue. So what are the facts that is in dispute? What is the law that is in dispute? All these things has to be found out. So the issues has to be found out. So that stage is called settlement of issues, where we read both the plaint and the written statement and identify the issues in the suit. That is mentioned in order 15, order 14. And after that, if you go to, if you have, I think you will have court visits in the coming, I think in the final year and all, you will have court visit. When you go to court visit, you will see in practice that if you go to courts, once issues are settled, the court will post the cases for pre-trial steps. It will be mentioned PTS in the diaries and all. What is this pre-trial step? So the pre-trial step is a stage where when we can take all the steps that is required to adduce evidence, everything that is required to adduce evidence in the coming stage. So that will include interlocutory applications, for example, for discovery of documents, for production of documents, inspections, commissions, and various other things like filing of interrogatories. All these steps help the help to adduce evidence in the next stage of the suit. So all these things will come under the pre-trial stage. Once the pre-trial stage is also completed, we call the suit as the suit is ripe for trial. That is, the suit is ready for trial. So the next stage will be examination of witnesses and submission of evidence. So this is a stage where all the oral evidences and the documentary evidences will be submitted, and examination of witnesses and the examination of party witnesses and all of those things will happen. Once the plaintiff's evidence is complete, then we go to the defense evidence. And when defense evidence is also completed, the evidence will be closed and the case will be posted to the next stage, that is hearing stage. All this is mentioned in order 16 and 18. You can go through those orders and you will get a clear idea as to how the examination of witnesses is done, and how a submission of evidence is done, all of that. And how hearing who has to advance their arguments first. All this is mentioned in order 16 and 18. So once evidence is also completed and it is posted for hearing, arguments will be advanced. And once arguments are also completed, the case will be posted for judgment. Once judgment is passed, the decree will follow. As you know, in civil cases, we have a judgment and a decree, unlike in criminal cases where there is only one judgment. Here we have a judgment and decree, and judgment will be pronounced first, followed by decree within the next 15 days. Decree is just a short, brief information. It will only have a brief information regarding what is the order that is passed, and what brief information regarding the parties' names and what was the suit for, and then what is the relief that is granted. That is all that will be there in decree, and whether cost is allowed or not. The reasons for the decision will all be contained in the judgment. Now we can actually say that now the suit is come to an end by passing the decree. But does it really end by passing the decree? No, because definitely there will be an aggrieved party in any suit. So what if the party wants to go in appeal? So then the suit here in the trial court, the suit will come to an end and will move on to the next appellate stage. The appeals will be filed and it will be heard. Then if there is any reference, review or revision, that also will be proceeded with. So once all of that is complete and we have an executable decree in hand, does that become the end of the civil suit? No, because there might be, for example, in a civil suit, there might be a decree, say that there is an order declaring that this particular piece of land is the plaintiff's land. And the defendant is directed to remove the compound wall that he constructed in the plaintiff's property. So there is a direction to remove the compound wall by demolishing the compound wall. But the defendant is not acting upon that order. Or once the decree is passed, the defendant will be called, or the losing party will be called the judgment debtor, and the winning party will be called the decree holder. So if the judgment debtor is not doing his part as per the decree, what is the remedy that is available to the decree holder? He can file for execution. That execution is mentioned in detail in sections 36 to 74 and order 20. So that is, once execution is also complete, we can for sure say that the civil suit has culminated. So these are the stages of a civil suit. Is there any doubt so far? Am I going too fast, or is it okay? The pace is fine.
No, ma'am, we are going in a medium pace. We are understanding it clearly.
Okay. Now we'll go on to the next our topic for discussion today. That is Order 9, Rules 1 to 14, Appearance of Parties and Consequences of Non-Appearance. So Order 9 has 14 rules. It's a very simple provision, very simple rule. Once you understand this, it will be very easy for you. Order 9 has rules 1 to 14. So as we said earlier, the first stage of a civil suit is institution, wherein a plaintiff is properly instituted in a civil court of competent jurisdiction. And once the suit is filed, it is numbered and registered with an OS number. Usually it is original suit number. The next step will be the court will issue the summons to the defendants, and the summons will provide a date of hearing when the parties are required to appear before the court. And here in the summons there is the hearing is given for appearance of parties. That appearance can either be personal, they can personally appear, or he can appear through his or her recognized agent or pleader. He can file the wakalat and appear through them. So moving on, the first rule in order 9 states that the appearance of parties on the date fixed in the summons is mandatory. If you look at the provision mentioned in the Bear Act, it says on the day fixed in the summons for the defendant to appear and answer, the parties shall be in attendance at the courthouse. Always, when you read the legislation, you should give attention to the words like shall and may. It denotes shall denotes a mandatory provision and may denotes a directory provision, which becomes ultimately the discretion of the court. So here in order 9 rule 1, the word mentioned is shall. So it is a mandatory provision that on the date fixed for appearance, the parties shall appear. Now, if they don't appear, what are the consequences? That is what is mentioned in the rest of the provisions. That is from rule 2 to 14. It deals with consequences of non-appearance. Rule 2 and 3. These two rules deals with dismissal of suit on certain occasions. Rule 2 provides that if the summons that was supposed to be served, it was not served because of the plaintiff's failure to pay cost. What cost? The cost for postage for service. We always have to pay the BATA. We are in court in legal terms. When we go to courts, you'll see BATA or BATA. They'll say that is the postage for service. We need to pay that cost and court fee for service into the court. And we also have to file copies of the plain that is to be given to the defendant. Only if these two are done, the summons will be properly served. So if the plaintiff fails to pay the cost or provide copies, then the summons will not be served. So in such situations, if the court sees that it is due to the fault of the plaintiff, the court may dismiss the suit. Here the word used is may. That is, it's up to the court to whether dismiss or give an adjournment if there are sufficient reasons. Here the proviso states that there will not be any dismissal of the suit if, even though there was a failure on the part of the plaintiff to pay such cost, defendant or his agent appears. In such circumstance, the court will not dismiss. That is why the term may is used. There is a discretion on the part of the court whether to dismiss the suit or to postpone the suit. Now, Rule 3 says that if on the date mentioned for appearance of parties, both the parties are not appearing, then when the case is called, plaintiff is absent, defendant is also absent. What happens? The suit will be dismissed. Here also the word used is may be dismissed. It is also the discretion of the court. The court may give another date for appearance. That is up to the court and the court's discretion. So Rule 2 and 3 provides for two circumstances where suit can be dismissed. One is due to the fault of the plaintiff, summons is not being served. Second is on the date when the case is called, both parties are not appearing. Now, what is the remedy available to the plaintiff if the suit is dismissed under Rule 2 and 3? That is mentioned in Rule 4. So, Rule 4 provides a remedy against Rule 2 and Rule 3. So, if the suit is dismissed as per Rule 2 or Rule 3, the plaintiff has a remedy to either file a fresh suit or file restoration. That is an application for the order to be set aside. And for that order, he has to show a sufficient cause as to why there was a non-appearance or why he had failed to pay cost. So on showing sufficient reason, the court may restore the suit and proceed with the case. So the remedy, there are two remedies that are available. That is either he can file a fresh suit or he can file an application to set aside the order of dismissal. Here in order 2 and order 3, dismissal is not a decree. So there is no appeal in this case. There is only remedy is fresh suit or restoration. Now, Rule 5 provides another circumstance where a suit can be dismissed. So when summons is served, imagine it is returned unserved. For any reason, maybe the defendant's the address could not be found, or any other such reason, the summons is returned by the process server. So on the date of hearing, when the court looks into the summons, it is returned unserved. if the summons has been returned unsserved, the plaintiff has 7 days from the date of such return to apply for a issue of fresh summons. He only has 7 days to apply for fresh summons. If within the 7 days he has not applied for fresh summons, here the court shall dismiss the suit. The wording is shall. So if he fails to do that, the court shall dismiss the suit. Here there is one small rider, which is within that 7 days, if the plaintiff comes to the court and says that he couldn't discover the residence of the defendant, or he says that the defendant is purposefully avoiding their service, or if there is any other sufficient cause for extending such time, court will extend the time of 7 days. But ultimately, if the plaintiff is not applying for fresh summons, the suit shall be dismissed. Here, the remedy is mentioned in Rule 5 itself. The remedy is only fresh suit. You cannot file for a restoration. You can only go for a fresh suit. Another circumstance where dismissal of. So now we have learned 3 circumstances where a suit can be dismissed. Now the 4th circumstance is if the defendant alone appears. That is mentioned in Rule 8. So when the case is called for hearing after serving of summons and plaintiff is absent, defendant is present, the court shall dismiss the suit. Here it is mandatory that the court shall dismiss the suit, provided if the defendant comes and he is admitting to the claims, whatever claim has been mentioned in the plaint, he is saying, okay, one part of it is true, he is admitting to those claims, then the court shall, as far as those admissions are concerned, pass a decree against the defendant and dismiss the suit. If there is no admission as such, the whole suit will be dismissed. The remedy available for the plaintiff for a dismissal under Rule 8 is only to apply for restoration of suit. There is no fresh suit. He can only apply for restoration because here the defendant had appeared. So there is also one more rider that any such application that is to be filed, you have to serve a copy to the opposite side and then only file. So the remedy available for plaintiff if the suit is dismissed under Rule 8 is that to apply for restoration of the suit by setting aside the dismissal order. The plaintiff will have to show sufficient cause as to why he did not appear on the date so fixed for his appearance. Here you have to see that no fresh suit can be filed and also notice of the application has to be served on the other side. Earlier we did not mention this this particular rule that notice has to be served for restoration. Why? Because their defendant's appearance is not there. Before defendant appears, the suit is being dismissed. That is why there is no need to file no need to give notice to the defendant. But otherwise, if the defendant had appeared on that day and the suit gets dismissed, then the defendant has the right to get notice of application to set aside the dismissal order. So these are the 4 circumstances under which a suit can be dismissed under Order 9. That is for the first appearance. These are some of the case laws mainly pertaining to Kerala High Court. In Benz Automobiles Private Limited case, the Honorable Kerala High Court has said that the term appearance that is contemplated under Rule 8 is a effective appearance and not merely a physical appearance. Why they say so is that these provisions will also apply to later stages of the code. For example, when the suit is posted for evidence. When it is posted for evidence, the plaintiff has to appear on the date that is posted for evidence and the plaintiff has to give evidence. If on that day the plaintiff appears, but he is not ready to give evidence, he is not filing a proof affidavit, he is not ready to give evidence, then that appearance is not an effective appearance. It is just a mere physical appearance. That is why that in that case also the suit will be dismissed, even though the plaintiff had appeared in that court. That particular provision is as per that particular provision, this decision has been made, which says that appearance should be an effective appearance and not a physical appearance. So this is pertaining to application of this order to a later stage of the suit. We need not concern with this provision right now because right now we are discussing on the date for appearance in the summons. We are dealing with only that. Here, effective appearance means his physical appearance only. Now, coming to the next case, that is Pillayatiri Ammal's case. Here, the court, what the court held is that, see, the plaintiff is absent, but that absence is due to his death. Then, can the court dismiss the suit? The court cannot dismiss the suit. In such case, because an order against a dead person is a nullity. So here the order, if even if the court does not know that he is dead, or nobody informs the court of the death of the plaintiff, and the court dismisses the suit, that order does not have any value. It is just a nullity. Legal representatives can bring that case back on the file of the court. So that is mentioned in this case, Pillayatiri Ammal versus Lakshmi Ammal. And another scenario another very interesting scenario is discussed in Philomena Joseph versus State of Kerala. I have only, in this particular slide, I have only mentioned certain interesting cases, but there are lots of other cases which you can research upon. But these are certain peculiar cases where the court has given orders. So in Philomena Joseph's case, what happened was the plaintiff, he himself came and said that he is not pressing the suit. That is, he is not proceeding with the suit, and that suit may be dismissed. There are certain circumstances when the plaintiffs come and say that, file a memo in court and says that he does not want to continue with the suit. And then what the court will do is court will dismiss the suit. But this dismissal cannot be said to be a dismissal under order 9 rule 8, because here he is admitting that he does not want any relief from the defendant, so he cannot restore the suit back on file or proceed further in any manner. In which, so that is very peculiar, and just to be noted that once you file a memo saying that you don't want to proceed with the suit and the suit gets dismissed, you do not have any other remedy under the law. So these are the three peculiar circumstances described in these cases. Can I move on to the next slide, or do you need more time with the slide?
No, you can proceed, ma'am. We have already noted down the 3 case laws.
Okay. So far what we have seen here is in cases where there is neither party appearing, or there is a fault on the part of the plaintiff to file or to give cost or something, or if the plaintiff does not appear. All these circumstances we have already covered. What if on the date of hearing the plaintiff alone appears and the defendant is not appearing? So in such cases there is 3 course of action that is mentioned in Rule 6. In Rule 6, what is mentioned is the plaintiff appears, but defendant does not appear. Here, the court has to see first whether the summons was duly served. If the summons was duly served, then the case will move on to the next stage, that is, ex parte proceedings will be initiated, and ex parte proceedings will go on. Secondly, it says that if the summons was not duly served, then court will issue a fresh summons. There was no summons served or anything, then the court will issue a fresh summons. Coming to C, summons was served, but there is no sufficient time for the defendant to appear and pray or answer to the questions and in the plaint. In such cases, what the court will do is, court will not take the defendant's absence into a record, but the court will adjourn or postpone the case and give notice of the new date to the defendant. So, 3 course of action if the defendant does not appear. If the summons is duly served, it will go to ex parte proceedings. If it is not served, fresh summons will be ordered. If the summons was served but there is not sufficient time for the defendant to come and appear, then the court will adjourn with notice. So in here, in 6 clause 2, what is mentioned is that if the fact that the summons was not duly served, or the fact that the summons was served but not in due time, is because of the plaintiff's fault or any delay from the side of the plaintiff, then the court shall order the plaintiff to pay cost for the postponement. Here also the word is court shall order the plaintiff to pay cost. So the court will mandatorily order cost. Now, what is the remedy available for the defendant under these circumstances. That is mentioned in Rule 7. When the suit is proceeding ex parte as per Order 9, Rule 6A, the defendant can, at or before the hearing of ex parte proceeding, appear and assign a good cause for his non-appearance on the date fixed for his appearance in the summons. So here what it means is that once the defendant's absence is noted, the next stage will be the case will proceed to the next hearing, that is ex parte evidence stage. In ex parte evidence, the plaintiff will come and adduce his evidence, and then after that it will move on to plaintiff's hearing on the play of the plaintiff. Then after hearing the plaintiff, then only the judgment and decree will come. So there will be subsequent postings after this particular posting. So the defendant can at any time before the judgment is passed, before that hearing, he can come at any time with an application to set aside the order of proceeding the case ex parte, and he has to assign a good cause for his non-appearance. In which case, the court will set aside the ex parte order on cost or otherwise and proceed as if he had appeared on the day that was fixed for his appearance. So Rule 6 and the remedy for 6A is mentioned in Rule 7. I think, yeah, Rule 9 also we have discussed. 8 and 9 also we have discussed. Now, so far we've seen provisions where there is one plaintiff or one defendant. What happens when that sole plaintiff is not present, and when what happens when the sole defendant is not present. But in most of the cases, we have one or more plaintiffs and one or more defendants. And in such cases, how is this particular order to be applied to those cases? That is what is mentioned in Rule 10 and 11. So Rule 10 says if the suit has more than one plaintiff and on the date so fixed for hearing or for appearance, one or more of the plaintiffs does not appear. So imagine there are 4 plaintiffs, 2 of them appears, 2 of them does not appear. What happens? Nothing will happen because the suit will be permitted to proceed as if they were all present. No adverse orders will be passed against those 2 plaintiffs who had not appeared. That is mentioned in Rule 10. Rule 11 says when the date so fixed for the appearance of the defendant, if there is more than one defendant, any one or 2 of the defendants is not appearing. Again, like there are 4 defendants, 2 of them appears, 2 of them does not appear. What the court will do in this stage is that it will not immediately proceed to the ex parte proceedings under Rule 6(1)(a). It will not go there. But what the court will do is that court will record that these 2, defendant number 3 and defendant number 4, these 2 defendants are absent and they will be ex parte in the suit. But the suit will proceed with the other 2 defendants. And at the time of pronouncing judgment, the court can, after looking into the evidence and everything in the case, pass judgment against these defendants who did not appear as it thinks fit. So what is to be noted is that it will not immediately go to ex parte proceeding with respect to those 2 defendants who did not appear. But the suit will proceed as usual, in the usual course. And in the end, only they will decide as to what is to be done with the defendants who had been ex parte. So that is rule number 10 and 11. Rule number 10 corresponds to when there is more than one plaintiff, and rule number 11 corresponds to when there are more than one defendants. Now, Rule 12. This is what I had mentioned a while ago, that Order 9 can be, provisions of the Order 9 can be applied to later stages of the case as well. That is, if the court directs or orders that the plaintiff or the defendant shall appear on a particular date, and if the plaintiff or the defendant does not appear so, without any sufficient cause, in such cases, the provisions that we mentioned right now from Order 9, Rules 2 to 11, we can say from 2 to 11 will appear accordingly. If it is a plaintiff, those provisions that is related to plaintiff will apply. If it is the defendant's non-appearance, the provisions relating to defendant's non-appearance will apply. So this Rule 12 is the rule that gives the court the power to dismiss or proceed ex parte in a later stage of the case, where there is a non-appearance when there was a specific direction to appear. This is again, the example can be said as when there is examination of witnesses. If the case is posted for defense evidence, defendant does not appear and reduce evidence, suit will be set ex parte. The defendant will be set ex parte and ex parte proceedings will continue. Because at that stage, since the plaintiff had already given the evidence, then the suit will move on to the next stage, that is hearing of the plaintiff's case, and then finally judgment and decree. So that is how this particular order is applied to the later stage of the case. Now we have only two more rules in this order that relates to remedy of the defendant if the ex parte decree is passed. Earlier in Rule 7, we saw where there was only an ex parte order and the suit was still proceeding. So what is the remedy available then? He could have filed a petition to set aside that order of ex parte proceeding, and he only needed to show a good cause for his non-appearance. Now imagine if that ex parte proceedings continued. There was evidence, then came hearing, and judgment was passed and decree was passed. That decree will be called an ex parte decree because the other side was not heard. Once the decree is passed, it is an appealable order also. So such a decree is passed against the defendant. Now the defendant comes. Now the defendant wants to proceed with this. What will he do? That is provided under Rule 30. So where a suit is proceeded against a defendant and it has culminated in an ex parte decree, the defendant can file a petition to set aside that ex parte order under Order 9, Rule 14, and he has to show a sufficient cause for non-appearance. Here you have to see that under Rule 7, he only had to assign a good cause for his non-appearance. That is not very stringent. He can say whatever reason that was there. But when it comes to Rule 13, the legislators have mentioned the word sufficient cause. So there are a lot of decisions which says what is a sufficient cause, what is a good cause, what is the distinction between these two. All these are dealt with in various decisions through judicial interpretations. So coming back to Rule 13, as we have seen, once the court is satisfied that okay, there was a sufficient cause for his non-appearance, the court will set aside the decree with such terms. There will be some term as to cost because there is a lot of procedure that had happened because of the lapses on the part of the defendant. So there will be always an order as to cost. Now there are two provisos and one explanation to this particular section, this particular rule. The proviso mentioned that like we said earlier, there were 4 defendants and only one of the defendant came up with a petition to set aside the ex parte decree against him. In usual cases, what we do is that we will only set aside the ex parte decree as against him and not against the others. But if the suit is of such a nature that it cannot be divided, for example, if it is a partition suit and all of these parties are included in the partition suit, so one person alone cannot come and set aside the decree and then get an order in his favor or against him. So in such cases, when the suit is not a divisible kind of one, what we do is that we'll set aside the suit as against all of the defendants, even though one person is only coming with an application. That is mentioned in Proviso 1. And in Proviso 2, what is mentioned is that if the court is satisfied that the defendant had notice of the hearing, he knew that the court had given this particular posting for the hearing, and he knew that the proceedings were happening ex parte, and he knew that ex parte decree was about to be passed, but he did not come to court. He is relying on the fact that there was an irregularity in the service of summons, but he was well aware that the suit was posted on such and such dates. If the court is satisfied that the defendant had such a notice, then the court will not set aside the order because he is trying to play smart, right? So in that case alone, the court will not set aside the order, but defendant will be left with no other remedy in such cases. But it has to be proved. That is the petitioner, that is the plaintiffs will have to prove with evidence that defendant had notice of the hearing. Now, what the explanation states here is that, as I said earlier, ex parte decree is an appealable decree. And if the defendant chooses to go in appeal against the ex parte decree, then he cannot file a petition under Rule 13 and set aside the ex parte decree. He can either choose one of the remedies. He can either go in appeal of the ex parte decree, or he can file under Rule 13 an application to set aside the ex parte decree. He cannot do both. Also, once he has gone in appeal, if he wants to withdraw the appeal, he can withdraw the appeal and then file an application. Otherwise, no application under this rule shall lie if the defendant has gone in appeal of the ex parte decree. And Rule 14, that is the last rule in this order, it again says that decree cannot be set aside without giving notice to the opposite party. Here the opposite party will be the plaintiff. So that is mentioned in Rule 14. So these are the certain decisions that I have written down. You may note that these decisions. It is mostly with regard to what is good cause, what is sufficient. There are a lot of decisions have been passed by the Supreme Court and various state high courts, which says what is the distinction between good cause and sufficient cause, and what cannot be a good cause, etc. But through all these judicial interpretations, what interpretation that is now given by the courts is a very liberal interpretation as to what is a good cause and a sufficient cause. And this second case, I think Sangram Singh's and Arjun Singh versus Mohindra Kumar and all are reported judgments, and they are landmark decisions of the Supreme Court, which deals in detail with Rule 7 and Rule 13, where setting aside of ex parte order and decree are concerned. So you may write down these decisions and let me know when you are done. I can move on to the next slide.
Ma'am, you can move on. I think they must have taken the screenshot of it.
Okay, sure. So now let's just do a quick recap of what we have learned today. So on the date of appearance, if both parties appear, the suit will proceed to the next stage, that is written statement, and then it will follow. If on the date of such appearance, neither party appears, that is both the parties are not appearing, then the suit will be dismissed for default. If the plaintiff alone appears, then there is three course of actions. One is to see if the summons is served. If the summons is served, ex parte or proceedings will be initiated. If summons was not served, court will order fresh summons. Now, if summons is served but not in due time, then the court will adjourn with a fresh notice as to the date of appearance. Now, if defendant alone appears and there is no admission of any claims, then the suit will be dismissed for default. But if the defendant appears and there is admission of claims, then a decree shall be passed on the admitted claims alone, and with regard to the rest, there will be a dismissal for default. And coming to remedies, we have for Rule 2, dismissal under Rule 2, Rule 3 and Rule 5, the remedy is fresh suit. For dismissal under Rule 2, Rule 3 and Rule 8, the remedy is restoration. So here if you can see, for Rule 2 and Rule 3 alone, we have two remedies, either fresh suit or restoration. That is fresh suit or restoration only for Rule 2 and Rule 3. Rule 5, the only option is fresh suit. Rule 8 dismissal, only option is restoration. Now coming to the defendant's remedy for ex parte order, when it is not culminated in a decree, it's under Rule 7 by assigning a good cause. And if it is culminated in an ex parte decree, then under Rule 13 by showing a sufficient cause. Now I need to tell you one more thing with regard to this application, that is the limitations for filing application under Order 9. So as we know that Limitation Act provides for limitation for filing applications, appeals, suits, etc. So Section 122 of the Limitation Act deals with restoration. So with the restoration petition that is under, like we have seen earlier, that is under Rule 5 Clause 2 or under Rule 9 for dismissal, and for Rule 4, what we the time period or the limitation that is given is 30 days from the date of such decree. That is a dismissal order. So we have 30 days to file restoration petition under Section 122. And under Section 123, for setting aside the ex parte order, again we have 30 days from the date of decree or order, or 30 days. In certain cases, the defendant does not even know that an ex parte decree exists in against him. In such cases, whenever he comes to know of the existence of the decree, 30 days from that date on which the applicant had knowledge of the decree, he can file the petition to set aside the ex parte order. So both the limitation periods are 30 days. We just have to see that it is in case of restoration, it is from 30 days from the date of decree, and in case of the ex parte orders, 30 days from the date of order or decree, or 30 days from the date on which the applicant has knowledge of the decree. So I hope I was able to give you a clear understanding as to the stages of a civil suit and the consequences of non-appearance of parties and possible remedies that are available and the limitations that are attached to them. So with that, I think we've come to the end of today's session. Thank you so much for patiently listening. And I truly appreciate the faculty of Havanur College of Law for giving me the opportunity to take this class for you. And if you have any further doubts or if you have any questions, you can, I think, put it in the chat. And if you have, after this, maybe if you have any doubts, you can email me and I'll be happy to respond. Thank you once again.
Thank you, ma'am, for your wonderful session. The forum is open for the Q&A session. If anyone wants to, please, I think one question is there in the chat box. Bhagya, could you please take over it?
Yes. So there's a question that says how to remember the Roman numerals of all orders or rules.
That you need to learn. There is no other, there's no easy way out, right? You will have to memorize it somehow.
Yeah, one more question is remedy available if there are delays in each and every stage of OS suit due to transfer of judges once in 3 years when we have several defendants in the case.
I didn't get that question. What is the?
Vasant, or can you ask the question? If you can just unmute yourselves and ask the
Yes, yes.
question.
Ma'am, like I filed a OS suit in 2008.
Hmm, hmm.
So with respect to that OS suit, each and every 3 years, the judge is getting transferred.
Yes.
So every stage it is taking 2 to 3 years, and the intensity of the cases in that particular case court is so much that day to day it is around 200 to 240 cases. So from past 17 years, I am just running behind, serving the notices, serving the summons, bringing LRs on record. This is what is happening. But can we approach any higher court with respect to this?
Yes,
Is there any
definitely.
remedy?
Definitely. See, these are this delay is the problem of our Indian legal system. We cannot do much about it. But if you need any quick remedy in the particular suit and the suit is getting very, very much delayed, what you can do is you can move to the High Court under 226 or 227, and then you can get an order to get the fix a time limit for the case to be disposed of. So the higher courts in here and all, we go under 227 or 226. What they'll do is they'll give a time frame. They'll fix a time frame. Maybe finish this case within the next 2 months or 60 days or 90 days. There'll be a direction like that, and that direction they have the lower court judges will have to follow. So in that such cases, once there's a direction, then the case will be posted every day, irrespective of whatever other cases. Then this case will be taken up and it will be finished within that particular time frame. That is the
Okay.
remedy that you have. You can move to the High Court. I think
Okay,
that
there's
is
one
all,
more
Fine.
right?
question. If in case of multiple defendants, one wishes to set aside the ex parte decree and the other wishes to appeal, how can that be proceeded with?
So here, say for example, one defendant has filed a petition to set aside ex parte decree in the lower court, and another defendant has gone in appeal. So you know the hierarchy of courts. Appellate court will always have a priority over the lower court. Definitely, the other defendant will come to the lower court and say that I have filed appeal. So what the lower court will do is that the lower court will keep that petition in pending and see what is the result in that case. So either one of this application can proceed. They both cannot proceed together. So if the suit is gone for appeal, then all the parties will have to appear there and give their replies there. And in such cases, the petition to set aside ex parte decree in the lower court will be dismissed.
Okay, since it's past 8 o'clock, will you be taking more questions because there are a few more questions, or do I
Okay.
have to ask them to mail them to you? There are
I
just
can
three more
take.
questions.
Yeah, okay. I will
Uh,
take those questions. Okay.
yeah, what remedy lies if the defendant has changed the address because of which summons couldn't be serviced?
The plaintiff will have to find out the address. Plaintiff is the one who is filing the suit. He has to find out the address of the defendant, because it's not the duty of the court to find out where the defendant is residing. Plaintiff will have to provide the address.
Okay, so why don't we proceed to execution stage after getting judgment? Why do we need decree? What is the difference between them?
Okay, that is a whole session to be taken separately. But briefly, I'll explain. See, judgment does not once judgment does not have not judgment. The decree does not have the reasons for judgment. Judgment is the reasons for the result of that particular case. So if there is a declaration that is order is given, says for example, it is declared that the plaintiff has the right to reside in particular plain day schedule property. That is the order. Imagine that is the order. Then why is the plaintiff given that order? Why didn't what happened to the evidence that was submitted to the defendant? All these things, what is the result of the evidences that were given? What is the result of the examination of evidences? How these both the sides have been heard, and how the judge has analyzed the case? All these reasonings will be there in the judgment. Decree is only with respect to, there will be a cause title, parties, what was the relief sought for, what is the relief granted, if there is there any order as to cost, what is the order as to cost. That is alone is the portion of called the decree. And civil suit can only be completed when there is a judgment and decree, and it is a mandatory in all cases there will be a judgment and decree. So I hope I'm clear.
Yes, ma'am.
And
So the last
once the
question.
decree is passed, you can take the decree and go for execution if you don't have any appeals.
Yeah, so the last question is, how do virtual hearings, online courts, affect the concept of appearance under CPC today?
So with regard to appearance, see, during COVID, every appearance was online, right? And even now, since we have all these DCMS and everything that has come into play right now, so Supreme Court has given various directions and has even issued rules with regard to virtual hearing. So appearance through the virtual hearing is also good appearance only. But there will be a procedure to be followed in case of such appearances. You cannot simply log in and say that I am here. No, that is not the way. But you have a detailed rules and procedures issued by the High Court as to how a virtual hearing has to be conducted. If you do that, then the hearing will be considered as that appearance will be considered as legal appearance. I hope I'm clear.
Yes, I mean there is one more question. Timeline for passing decree. This was one person has
So
asked.
Execution order.
Execution of decree.
There is if you are asking for limitation, then it depends on the kind of suit. The execution the limitation will come. As to timeline, there is no timeline. It has to happen when it happens, like, or it has to go through again several stages and processes, and then only we cannot fix a particular timeline for an execution of a decree.
Okay, thank you, ma'am. With
Thank
these
you.
questions, everyone's flooding with thank you for the excellent seminar, for the excellent session. So
Thank you.
even me, on behalf of all our faculty, our management, we thank you, for giving us such an insightful session.
Bhagya, sorry to
Yeah.
interrupt. I would like to call our principal, Srimati Lalita M. If you want to speak a few words.
Hello, ma'am. Good evening. Hanushri, ma'am, for your entitled speech, it is really great for our students, and it has given much information for our students, how the civil procedure will be go, everything it will be confused for them. And whatever the classes we take up also, this type of in a seminar, that it will be helpful for the students. And thank you very much for your enlightened speech for the student, ma'am. Thank you very much.
Thank you so much, ma'am. Thank you so much for
And
giving me this
thanks for the
opportunity.
Rimya ma'am also to arrange in such a useful program and giving a useful thing for the students. Thank you, ma'am.
Thank you, ma'am, for your kind words. Over to you, Bhagya.
Yeah, so that's what I was saying. All the nuances of a civil suit also you thought is right from shall and maybe's difference. So we realized that even words carry weightage in law. So thank you for that. Thank you for actually taking us through the stages of a civil suit. Thank you for being here. I also like to thank our principal for giving us this platform, without which we couldn't hold this session today. Thank you, Lalita ma'am, for giving us this platform. I thank the management members also for giving us this platform again to organize this function. I thank Hema ma'am is here. I thank our assistant professor Hema Selvi ma'am for being present throughout the session. In fact, I thank Ramya ma'am, who day in and day out has stood as a backbone for this program and has seen that it is carried on well. I thank all the participants who have been dropping off and coming on, and with or without stable connection, they have stood from the beginning intact in this program enthusiastically. I thank all the participants. I thank the back end team. We are like 8 or 9 of us who have been meticulously planning this webinar. I thank them also. And yeah, that is it. I thank each one of you present here who made it possible for this seminar to happen today. Yeah, thank you. That's it.
Thank you so much, Anusri ma'am. There are few questions left out. There are few questions left out. I think they will email to you if they have any
Yes,
queries.
yes.
Is that
Yes,
fine?
yes.
And there was a
Yeah,
question
no
like
problem.
whether PPT can be shared. So
Yeah, I
if
will
it is,
share it to you. I will share it to you. I will share
yeah,
it to you.
okay. Thank you so much. Have a good
Thank
day.
you.
Thank you so
Thank
much.
you.
Thank you.
Have a
Thank you,
good day.
ma'am.
Thank you, ma'am, it was very precise, and thank you so much for your time, ma'am.
Thank you. Thank you so much.
Thank you.
So we are winding up the session. Thank you, all the participants.
Thank you, Ramya ma'am.
Thank you, ma'am. Thank you.
Thank you very much.
Thank you.
Bye
Thank
to all.
you. Good night, Shivratri.
Thank you.
Thank you, everyone.